Trademark denied for ChatGPT. The U.S. Patent and Trademark Office has denied OpenAI's applications to trademark ChatGPT and GPT. The final office action states, registration is refused because the applied for mark merely describes a feature, function, or characteristic of applicants' goods and services. As the USPTO explains, a mark is merely descriptive if it immediately conveys information concerning a feature, quality, or characteristic of an applicant's goods or services. A proposed trademark, such as a word, phrase, or logo, can only function as a trademark if it's distinctive. Distinctiveness is often ranked as follows, from most to least distinctive. A fanciful mark, which is considered strongest, includes invented words like Xerox and Kodak. An arbitrary mark often uses a word with a common meaning and applies it to goods or services with no relation to that common meaning. For example, Apple for computers. A suggestive mark suggests a quality or characteristic of the good or services. For example, Microsoft for software for microcomputers. A merely descriptive mark merely describes some feature of the goods or services. For example, waterproof brand running shoes. Generic marks simply name a product. For example, Apple brand apples. In this case, said the USPTO, evidence shows that chat means a synchronous exchange of remarks over a computer network. Further, the evidence of record also establishes that GPT is a widely used acronym that means Generative Pre-trained Transformers, which are neural network models that give applications the ability to create human-like text and content, images, music, and more, and answer questions in a conversational manner. Also, the evidence of record shows that both the wording chat and GPT are used descriptively in applicants' software industry to refer to a particular type of software where users may ask questions and an AI model then answers those questions based on data that has been inputted into the model. The USPTO noted that two major reasons for not protecting descriptive marks are 1. To prevent the owner of a descriptive mark from inhibiting competition in the marketplace, and 2. To avoid the possibility of costly infringement suits brought by the trademark or service mark owner. In response to the refusal, OpenAI may assert a claim that the applied for mark has acquired distinctiveness under Trademark Act Section 2F. This section states, nothing in this chapter shall prevent the registration of a mark used by the applicant which has become distinctive of the applicant's goods in commerce. This distinctiveness can be shown via things like verified statements of long-term use as a common law trademark, advertising and sales expenditures, examples of typical advertisements, affidavits and declarations of consumers, and customer surveys. As the USPTO notes, this evidence must demonstrate that the relevant public understands the primary significance of the mark as identifying the source of applicant's product or service, rather than identifying the product or service itself. In determining whether a mark has acquired distinctiveness, the USPTO examining attorney will consider the following factors. 1. Association of the mark with a particular source by actual purchasers, typically measured by customer surveys linking the name to the source. 2. Length, degree, and exclusivity of use. 3. Amount and manner of advertising. 4. Amount of sales and number of customers. 5. Intentional copying. And 6. Unsolicited media coverage. No single factor is determinative, and all factors are weighed together to determine whether the mark has acquired distinctiveness. Need to protect your brand? Book an appointment with us at www.eonlaw.com. Eon Law. Unleashing Genius.